What? Okay.
Hello.
We're live.
We're live. Maybe Lisa should begin, Dr. Prasad.
Okay. Sorry for the technical glitches, and we are ready to broadcast, and it is already started. I could see the attendance are nearly 200. We had people across the globe. So welcome to this session on clinical legal education and international perspectives. We are very sorry that the actual organizers have ran into some trouble with technical glitch. So I'll be hosting till they identify the technical glitch. So we would be starting in a few seconds. Professor Krishnadev Rao, are you available? So we go ahead with the program because we already lost 15-20 minutes in this. Maybe I will request Professor Lisa Bliss to start with. She is from USA. I'm sorry I couldn't introduce anyone properly because I am not prepared for this. I request each one of you, please introduce yourself and please start your presentation.
All right, thank you very much. So my name is Lisa Bliss. I'm Associate Dean of Experiential Education and Clinical Programs and a clinical professor at Georgia State University College of Law in Atlanta, Georgia. And what I've been asked to do today is just talk a little bit about the development of clinical legal education in the US. So from the US perspective, what were some of the factors that influenced the growth of clinical legal education here, including the role of our accrediting body for legal education, which is the American Bar Association, and a little bit about the influence of professional associations of clinical legal educators, the influence on legal scholarship in the development of clinics in the US. And then I'll just share a couple thoughts about where clinical legal education is today and the impact of COVID-19, which, like the rest of you in the world, we have been dealing with here in the US. So I guess the first thing I just want to say is that clinical legal education is just about real life and real experiences, and how real experiences in the law and in justice can really influence the next generation of actors in our justice system. And those that next generation, those actors are students. And I guess I wanted to share early on that my own experience as a law student in law school in a clinical legal education program really inspired my own interest in helping people get access to justice and to become a clinical teacher myself. So I think it's a really transformative and powerful form of legal education. So just a few highlights kind of on the historical evolution of clinics in the US. In the US, clinical education, you know, at least as a concept, was developed, you know, sort of in the first half of the 1900s. You know, early commentators started thinking about the best ways to train students to become effective lawyers. That didn't really take off for a while. As early as 1921, the Carnegie Foundation for the Advancement of Teaching funded a study on legal education known as the Reid Report. And so as early as 1921, folks were thinking about what were the necessary components of a legal education, and that was, you know, general education, theoretical knowledge of the law, and practical skills training. So that's a long time ago, and yet it really took a while for clinical education as we know it today to take root. So by about the early 1950s, there were some law clinics. They were being run by law schools and other organizations. They weren't necessarily formalized, and some of them were not really even necessarily a part of the law school curriculum. what really influenced, clinical legal education taking root was around in the 1960s. And during that time, there were sort of this confluence of factors that came together and sort of spurred the evolution of clinics. One of that was just the social unrest of the time, sort of response to social activism, which was definitely a very important part of society here in the US in the 1960s. Students also were demanding that their legal education be more relevant and connected to social issues. And then I think even more importantly, there were all these external influences that that really influenced the development of clinical legal education since that time. And one of that was just the infusion of money to support the development of clinics. So from about 1959 or 1960 to around 1978, the Ford Foundation, a private foundation, provided, I think, almost $13 million in grants to more than 100 law schools. And this really helped law schools start to develop what we kind of know now as law school clinics. And again, this really was in response to students calling for more social relevancy in their education. And another thing that's really important to mention is that clinical legal education really has its roots in the US legal aid system. So there were lawyers at that time who were representing poor people in the civil context and in the criminal context. And they were working in legal aid offices, and they became some of the first clinical legal educators. There are still a lot of clinical legal educators that come from that background, that legal aid or legal services background. And so there's always been a very strong relationship or kinship between legal aid, between pro bono, and between clinical legal education itself. There was also money that came from the US Department of Education. So at one point in the late 70s into the 90s, the US Department of Education also gave money to help develop law school clinics. So those sort of contributions, I think, really helped clinics take root in law schools. And there's no question that external funding really had a big impact on getting clinical legal education started. And that's still true today. We're not necessarily getting government funding, but there are individuals and private foundations that are still giving, in some cases, very large gifts to help start clinics. Couple of examples. There have been, within the last couple of years, immigration is a big issue in the US, and there have been some pretty large gifts to help start immigration clinics. My school was the beneficiary of one. And then, other donations to help start other kinds of access to justice programs in law schools. So law schools definitely benefit from that kind of support, and a lot of clinics are started with external support, or at least the external support is a way for the law schools to agree to make their own commitment. What we think of about the modern clinical movement, or what's been called sort of the second wave, by some clinical scholars who were sort of thinking about this trajectory of legal education in 2000. That second wave was really the time between the 1960s and the 1990s. And at that time, clinical legal education really grew into a formal pedagogy, a formal way of thinking about teaching, and that really helped, I think, solidify its place as a fundamental part of the law school curriculum in the US. Clinics have also always had this strong social justice ethos, and that was rooted in the legal aid movement, and also just the social movement of the 1960s. So that social justice component was really a piece of clinics from the beginning. And clinical professors themselves saw themselves as teachers who were helping to expose law students, not just to legal skills, but sort of helping them think about the role, the values of the profession, thinking about promoting justice, fairness, improving the profession, and helping students think about their own professional development as lawyers. And that has sort of grown into what we now think about, or what we now call as professional identity formation. The other big influencing factor, I think, in the growth of clinical legal education was the emergence of clinical scholarship. So in the 70s and 80s, clinicians started really engaging in scholarship to examine aspects of the lawyering process, theories about lawyering, theories about supervision, and sort of integrating experiential learning theory and applying it in the law school context. So there was this whole body of work that was developed by clinicians who were really thinking very intentionally about teaching, and that sort of grew into this idea of clinic teaching as a methodology, as a pedagogy. And also the other piece that really became important at that time too was thinking about clinical methodology or clinical pedagogy as something that included reflection. Some other external factors, the American Bar Association is sort of the national association in the US that governs lawyers. And it is also the accrediting agency for law schools. And in 1969, the ABA created a model student practice rule. And so that was really important too, because eventually, and certainly now, but many years ago, a lot of states started implementing student practice rules that gave students the right to practice in court on behalf of clients. They were doing so under the supervision of lawyers, and that really moved clinical legal education forward because it allowed students to inhabit the role of representing clients themselves, of course, under the supervision of their clinical professors who are also licensed attorneys. So now we have all 50 states have student practice rules, and students are allowed to practice under supervision. Another really important piece of our clinical history is that in 1996, the ABA started to require that every law school had to offer either a live client clinic or some other real life practice experience. And so since then, every single law school in the US has law clinics and or externship programs. That's just another form of clinical legal education here, where students get academic credit for working under supervision in government agencies, nonprofits, and in the courts. So today, clinical legal education in the US is really a method of teaching that has a couple of really distinctive features. And the focus of that is really that students are confronted with problems or situations of the same kind that any lawyer would confront in the practice of law. Students deal with those problems in the role of lawyer. So they're doing that with supervision. And then the students have to work with their supervisor, with other students, and they're really learning the process of how to identify and solve those problems. And then the last critical piece is that students, their performance is going to be subject to critical review in the form of self-reflection and feedback from others. And so those features are kind of what we understand as kind of the clinical method here. So that kind of brings us up to the more recent past. I mean, since 2000, clinical education has really expanded. And in the beginning, clinics were really focused perhaps maybe on more general civil clinics, helping clients in civil matters, or maybe criminal defense clinics. And in the last 20 years, we've seen a tremendous amount of specialization. So for example, the clinic that I run is health law focused. It's a medical legal partnership clinic. So I have both law students working together with medical students in my clinic. We're working on focusing on how to address the social determinants of health, and handling things like disability, housing conditions, public benefits. Some other interesting examples are just specialized clinics that deal specifically with women's rights, workers' rights, domestic violence, immigration, tax, small business clinics, First Amendment clinics. I was researching something else the other day, and I found a clinic in New York City that's for film and documentary makers. We've got juvenile law clinics, trademark and patent, family law, mediation, animal law, veterans law. And I think what's interesting now is that the newer clinics are focused on technology, legal data, and legal analytics, which is sort of a hot topic in law practice right now as well. The other thing that has been happening sort of in parallel with the development of clinics is that there's been a large emphasis on externships as a form of clinical legal education. And during this last, 20 years or 15, 20 years, the supervision of externships has become more professionalized, and clinical externship pedagogy has also developed pretty significantly. So, students have a really rich menu of things to choose from here in the US. And in some cases, students choose their law schools based on the kind of clinics that are offered. I think I'm doing okay on time so far, but please let me know. The last couple things I wanted to share were just the impact of accrediting bodies and associations. So the ABA is the accrediting body of American law schools. And in 2015, the ABA mandated that all graduates of the class of 2019 had to complete at least 6 credit hours of experiential courses. And so that includes clinics, externships, or simulations. So that has inspired not only more clinics, but also more hybrid and interesting sort of offshoots of the clinical model. The other thing is that there are two very large association of clinical educators. One is the Association of American Law Schools section on clinical legal education. That section is one of the most largest within, we know it as the AALS, that plans an annual conference for clinical educators, and that's usually attended by 800 people, though there's far more than 800 clinicians in the US. In the early 90s, another independent professional association of clinical educators called the Clinical Legal Education Association was formed. And that was formed as a way for clinical educators to be able to do things that they couldn't do within the structure of the AALS. So clinicians could take positions on political matters, lobby for changes in ABA standards and that sort of thing. So those two associations are really important. They help clinical educators come together for conferences, and they really work together. And so COVID, right? In March, COVID forced all of our clinics to move online. That was a really disorienting moment for all of us. But it was an emergency, and we had to act very quickly to make sure that our students, our clients, our staff, everybody was safe, and yet we were still discharging the obligations to our clients. And so this goes back to, clinics are based on real practice, and pivoting to online client representation, attending video hearings, doing all of those things, that's about as real as lawyering can get, because lawyers all over the world were kind of having to deal with the same problems in terms of client communication and other impacts from the pandemic. And one of the great things about having these associations of clinical educators is we were able to sort of crowdsource problem solving related to COVID. So, within a matter of days, we were able to troubleshoot questions. There's a clinical listserv. We got help from clinical educators all over the country to develop policies, to talk about how to handle clients, how to get our university mail. So we had to pivot very quickly, but the technology let our students work remotely. Most of our clinics have client management software. So we've worked around COVID. We've learned a lot. We've used this summer, when a lot of clinics aren't operating, although some are, but we're learning lessons from each other about how to pivot to completely online. I think the positive impact of this is really creating new ways of doing things and forcing us to reimagine, what our clinical practice will look like going into the fall. I'm in a state that is open, so my clinic is going to be partially online and partially face-to-face, and we're really having to think about how to do that successfully and safely. And I guess that I will say that when the pandemic finally is behind us, I think the way that law schools and lawyers and all of us in the justice system are really this is really going to transform the way that we work, and also force us to rethink the role of clinics in licensure of lawyers to practice law, and just how we engage with clients and with communities. There are a lot of impediments to that, but we're working through them. So I'm quite interested to hear about how the experiences from other parts of the world, and all of you on this panel, how things compare to how we're dealing with COVID, and what impact that's going to have on the future of how our clinics operate. So I think I'll stop there and pass it on to the next panelist. And if there are questions later, I'm happy to take any. So thank you.
Professor Lisa, this is Ajay Thomas. I'm not too sure whether you can hear me. If you can hear me.
Yes.
Yes, excellent.
Yes.
Ladies and gentlemen, my extreme apologies to all of you. We had a technical problem, and that's the reason we had to start late. So on behalf of the organizers, please accept my apologies for that. And Professor Bliss, thank you for so graciously stepping in despite the technical issues. You have not had the privilege of, or rather the pleasure of an introduction. So let me do the introduction at the end of your speech. So ladies and gentlemen, here's a little about Professor Lisa Bliss. Professor Lisa Bliss is a Fulbright scholar. She's a clinical professor and the Associate Dean of Experiential Education and Clinical Programs at the Georgia State University's College of Law. Additionally, she directs and teaches in the Health Law Partnership Legal Services Clinic. Professor Bliss has had multiple leadership roles in professional organizations and has received several awards for her work. She's an elected member of the Board of Directors of the Global Alliance for Justice Education and is in her second term as co-president. She has also served 2 terms on the Board of Directors of the Clinical Legal Education Association. She has had the opportunity to train law teachers internationally and most particularly in Southeast Asia, including the jurisdictions of Thailand, Myanmar, Vietnam, where she has worked tirelessly to develop and strengthen experiential education and law school clinics. So, Professor Lisa Bliss, thank you so much for your insights into the clinical legal education system in the United States of America. And from the United States of America, we now move on to the Cape of Good Hope, to South Africa. And from South Africa, we have the next speaker who, if I would not be exaggerating if I were to say that our next speaker is a living legend in the field of clinical legal education. Ladies and gentlemen, I present to you Professor Dr. Javid J. McCoy-Mason. Professor Mason is a professor of law at the Center of Socio-Legal Studies at the University of KwaZulu-Natal in Durban, South Africa. He's also an advocate of the High Court of South Africa, a visiting professor at numerous international law schools, and the founder of South African Street Law Program, which is a clinical law program which trains students to provide lay people with information about the law and how it used to be, how it can be used in daily life. Now, Professor McCoy-Mason began teaching law way back in 1971, and I must admit that I was not even born in 1971. So, ladies and gentlemen, you get a feeling of the wealth of experience that this gentleman has. Professor McCoy-Mason established the first law clinic at the University of KwaZulu-Natal in 1973, and the first street law legal literacy program in South Africa in 1986. He has conducted clinical legal education training programs for law teachers and clinicians in South Africa, West Africa, and East Africa. And he's been a member of the International Bar Association's Continuing Legal Education Panel for Developing Countries, and has also helped draft legal aid legislation for countries such as Afghanistan, Sierra Leone, Uganda, and Kenya. Ladies and gentlemen, I can go on and on with the numerous accolades and achievements of Professor Mason, but due to the paucity of time and that we've lost half an hour due to technical issues, I'm going to now invite Professor Dr. David J. McCoy-Mason. Sir, the floor is all yours.
Thank you very much, Ajay. Just to say, Lisa has done all the heavy lifting, so I'm not going to repeat the stuff that she said. But I'm going to try and do in the allocated 15 minutes what I was asked to do. That was firstly a little bit of historical background to the South African system, something about the types of clinics and maybe the lessons we've learned from them, and then lastly dealing with the COVID epidemic. Okay, There's a slideshow here as well. RJ, if you can just flick it. RJ, are you flicking the slideshow or not?
Yes, Professor, I am there. Let me
flick it twice. Okay, we've done all that. Right, just next one. I'm not going to repeat it. Next. Okay, just to say 73, go back one. Yeah, 73, we had the first International Legal Aid Conference in South Africa. And there for the first time, we had pioneers of the American clinical movement. So we had Dean Kenneth Pye there. For one person, we had Clinton Bamberger. We had a number of well-known American founding fathers of the modern clinical movement. And I'd heard of clinics for the first time at that conference, which I was conference secretary for. The only existing clinic was one at the University of Cape Town, run by law students, and another one which had opened up in Johannesburg in April. So immediately after this conference in August, I went to the dean and said I wanted to start a law clinic. He said, okay, as long as it doesn't cost money, go ahead and start it. And so we started the third one in the country at the University of KwaZulu-Natal. Within 10 years, more than half the law schools had law clinics. The early clinics, just like the American ones, tended to focus on legal aid rather than legal education. So they were all called legal aid. 1980, the second was I'd gone off to America on a visitor's program as dean of the faculty. I've been trying for years to say, okay, law clinics are great because we're helping people in trouble, but how do we stop people getting into trouble? We need some sort of educational program. That's where I met Ed O'Brien, and that's where I then brought back the idea to South Africa. It's a bit tricky. It was at the height of the apartheid era when they declared a state of emergency when Ed O'Brien actually visited us, but I managed to work through the security police and everything, and we got the thing going. Next slide, please. Next slide. Where's my slide projector? RJ, next one. Sorry, technology, let me just carry on. Anyway, what happened? Okay, 1997, I was asked to go to, 1996, asked to go to Oxford and talk about South Africa's new democratic policing models and what was done to monitor them. And I said, I'll come on one condition, you let me talk about law clinics and street law in South Africa. And so the Ford guys said, fine, you can do a little seminar, which I did. They said, okay, next year you organizing a symposium. Just keep going back, RJ, to the third slide. You can organize a symposium for 70 public interest lawyers and academics from Eastern Europe and Russia, which I did. And I introduced them to the South African street law program and to the clinical program. And out of that, developed a whole, already there were some programs running in Eastern and Central Europe, but this then led to the Ford Foundation, Open Society, then doing a whole lot of other clinical programs in Eastern Europe and Russia. We've gone to the end. Let's not worry about the slides. You can send them out to people later. What I'll talk about now is just, we had a number of challenges which I think would be useful for people to know about during the early stages. For instance, when we were setting up the live client clinics. Now remember, this was apartheid South Africa, so the security police immediately thought this was some sort of communist plot, that we were now going to undermine what was going on. It was at the time more than 500,000 black South Africans being arrested every year for not carrying internal passports and things. So what we had to do was to overcome a number of these types of problems. The first one we had, of course, was the Law Society saying, how can you have students giving legal advice they're not qualified? So we said, okay, what we'll do is we'll get in some of your guys as supervisors. So we sorted that one out. Then we had the problem about security police saying this is a communist threat. So what I did then was I made sure that we got some members of the Law Society on our management committee to say, look, these guys are implementing the law. They're not going to be communists or anything else. The problem of trying to get clients, we dealt with churches, we dealt with community halls, church groups, all these sort of things. It was all operating from my office, so what I had was portable files. I'd go down, keep the portable files, and we would work in those sort of organizations. Then there was the issue, well, what sort of credit can the students get? Because as you know, there's quite a lot of bureaucracy in universities. So what we did was we took an existing program like a research project and said, okay, as your research project, what you can do is actually get some practical experience as well. You work in the clinic and you write up some of the case studies and you hand those in as research projects. Before, when I became dean, I was able then to get it into the proper curricula later on. So we had a number of those issues. All of them we were able to deal with. We ran the thing on a shoestring and it worked very well. With street law, it was a similar sort of challenge in some respects. We had to get permission in those days from 16 ministries of justice. The apartheid government had a ministry of justice for each ethnic group. So we had to negotiate with all these guys to try and let us start these programs. And the way we did it was to expose them to an actual street law lesson and show them what we were doing. And we had to be very careful that we were shown to be non-partisan, was sort of disguised human rights teaching. What we did was we'd always say, what are the arguments for? What are the arguments against? What do you guys think? And we even managed to do it with 500 prison officers at the height of apartheid in Pretoria with Ed O'Brien, where we got prison officers arguing about the pros and cons of segregated housing. So one was able to do all these things if you use the system properly. Today, there's live client clinics at virtually every university in South Africa. There's also a street law program at 9 of them. Our street law program, for instance, in Durban goes out and services 102 high schools in the area. The students write up their experiences in case books, and as Lisa said, there's a reflective element to it as well. So I think later when the panelists, people have got questions, I can tell them quite a lot about it. Just to say, the deans have now said that all law schools must have clinical programs in them. And that's interesting because we influence the Nigerians and their legal aid, their legal education council has made it compulsory in Nigeria. Bruce has fond memories of one of the trips we took to Nigeria as well. Just to say, I know we lost a lot of time, so I'm going to whip through this and leave it for questions, but just something about the COVID pandemic. We, like I think Lisa and a lot of the other clinics, were shut down. We had a very heavy lockdown in South Africa, so that the law clinic couldn't operate. But what I did was I arranged for a book to be placed at the security guard's entrance at the gate of the university, so that if people just walked off the street looking for the law clinic, we could record their names and contact details on their cell phone. And it was possible for the law clinic staff who were working from home to have teleconferences with them, teleconsultations. So that was for walk-in clients. Likewise, we were able to service the existing clients by using teleconsultations as well, rather like telehealth. And then because the courts were open, where it was urgent matters that went to court, you could always arrange to meet the clients down in court. So that's what we were able to do with the street law program, with the live client. With street law, what we did then was we are doing online teaching, is what Bruce and other people have been talking about. Online teaching is becoming more and more important for everyone. As Lisa says, there's going to be a big change once this epidemic stops. But I myself also do a lot of training of doctors and nurses. And I've been getting a lot of queries about ethical problems arising from this. Apart from the human rights violations, which are things which the law clinic has had to deal with, and I know in India and other countries you've had the same problem where the police have got overzealous and assaulted people and so on for breaking minor regulations. But I get a lot of queries on the medical ethics side. Queries about, what about informed consent? Can people be tested without their consent? And we've got a lot of regulations which say they can, if necessary. What about confidentiality? Is it confidential? Well, you have to tell people if you're going to be a danger to them, you have to report it. But once it's in the database, it is confidential. So street law became sort of street law plus. We were giving advice to those sort of things. We had problems of doctors saying, look, there's a delay of 2 weeks getting results. I've got to refer this guy to a specialist. The specialist needs to know his status for COVID. What do I do? Do I hang on for 2 weeks? I said, no, of course you don't hang on for 2 weeks, because his status might have changed completely. You have to then get hold of the private hospitals or persuade government to partner with them because they can give you results in 24 hours. So there are those sort of things. Then we had problems about workers saying, I don't want to go and work. We haven't got proper protective clothing, proper protection for us, PPE as they call it. You know, are we entitled to not go to work? So I had to look at all the ethical rules of the different professions for nurses and doctors and the international conventions as well, and come up and advise them on that. And then we even had doctors at hospitals, again, in the Cape, who were saying, okay, we've got all this PPE that we need, but I still don't want to treat COVID patients because it's a risk. So again, I had to give advice for those things. So street law became a sort of street law plus type program for during the COVID epidemic, and also has now been used. It will be used on online teaching as well. So just in conclusion, we followed a few years later than the Americans did. We had to adapt it to the African situation. We've now got law clinics, the live client clinics, and the which take a number of different forms, incidentally. Lisa mentioned some of them there, but some of them are on campus, some are off campus, some of them are mobile. We don't have, as India has some wonderful community-based clinics in the Philippines, we don't have those. Just lastly, on the associations we had back in 1987, we had an association of university legal aid institutions set up, as we called the clinics then. And I helped set up a trust in 1997, where we actually funded nationally all the law clinics. Both those models now have been looked at by Poland and Nigeria and have been introduced. Anyway, I've had a lot of fun since then, going all around Eastern and Central Europe, and even Bruce and other places as well. So really, it's been a great experience. And I think the South African model has been particularly useful for developing countries, which haven't got massive resources. I know that in the so-called developed world, you know, the ratio maybe is 1 to 10 or 1 to 15 or something like that, client clinics. At Wits University, for instance, in South Africa, it's almost 1 to 100 or something. And most of ours are working at 1 to 20, 30, 40, 50. Our street law program, one law teacher handles 120 students or something. Anyway, we've got lots of creative ideas. We can share them with everyone. I think my time is up. Thank you very much, Professor Prasad, for giving me the time. Thanks. Or RJ is back doing it. I don't know who's doing one of them. Thank you.
Thank you so much, Professor Mason. This is one of those days when everything that could go wrong has actually gone wrong. So
Okay.
you see my video through the screen, but I am speaking through my telephone. So, but ladies and gentlemen, that's life, I guess. When things have to go wrong, they go wrong, and they go horribly wrong. But I am delighted that despite everything going wrong, we're still online and the show goes on. So, Professor Mason, thank you so much for your insights into the clinical legal education system in South Africa. Thanks for those insights into the genesis, its development, and the stage at where you are today. Now we move on to our next speaker. From South Africa, we move on to Bangladesh. From Bangladesh, we have Professor Mizanur Rehman. Professor Mizanur Rehman is currently the senior most professor at the Faculty of Law at the University of Dhaka. He's also an adjunct professor at the Department of Law and Human Rights at the University of Asia Pacific. He's a former chairperson of the National Human Rights Commission of Bangladesh, a position that he served with great distinction for 2 tenures. He's been teaching since 1985 and has been a visiting professor to Umeå University in Sweden, the University of Oslo, Kathmandu School of Law, the Tver State University in Russia. I must say that he's a much awarded professor. The Society of Indian Law Firms and the Menon Institute of Legal Advocacy and Training awarded him the Best Law Teacher Award in 2010. He's a recipient of the Mother Teresa Gold Medal for Peace in 2010, the Nelson Mandela Gold Medal in 2012, the Mahatma Gandhi Peace Award in 2011, and the Michael Madhusudhan Datta Award 2012 for the promotion of human rights. Professor Rehman has contributed to the development of legal education in Bangladesh throughout his career by research and experiential learning. As an educationist, he has made significant contributions to the development of novel techniques in legal pedagogy through his methods of law teaching and his very unique theory of rebellious lawyering. Ladies and gentlemen, I have great pleasure in presenting to you Professor Dr. Mizanur Rahman from the University of Dhaka. Professor Rahman, over to you.
Thank you, Ajay. And at the very outset, ladies and gentlemen, let me express my very sincere gratitude to the organizers of the webinar. I feel very humble and at the same time very honored to be in the midst of this galaxy of clinicians from around the globe with experienced clinicians like David, like Professor Bliss, and my good friend Bruce. Once again on the same platform, it's a wonderful experience sharing my very little experiences I have had over the years in terms of legal education and associating myself with the clinical experience as well. But let me, as the point of departure, start from an observation made by, well, my philosopher guru and teacher, Professor Madhava Menon. Well, Professor Madhava Menon had said and observed that legal education is more of a public good than a private good. And I reinterpreted Professor Menon's vision in the context of Bangladesh and more so in the context of South Asia to be that this public good has to be defined as empowerment of the poor and the vulnerable communities in the society. So from that perspective of public good, what legal education contributes and how it contributes and where the clinical component enters into legal education and the profession. So from that angle, I'll be trying to share some of my experiences with you this afternoon. Our experiences with clinical legal education have had several stages in Bangladesh. I just named these stages very briefly, and my presentation would be in a thesis form. So I'll not go into elaborate, description or explanation of the things, but I hope that this learned gathering would be able to extract the essence of the points that we making here. So as I mentioned that we have had several stages in our clinical experience. The number one was introduction of the clinical method as such, the method of teaching. And that was done by none else than Professor Madhava Menon along with Professor N.L. Mitra while they were working in the National University of Indian University at Bangalore. So that is when they come in the beginning of the 1990s of the last century. That was the first ever exposure of the Bangladeshi teaching community to the clinical method of learning as such. So the first stone was laid by Professor Madhava Menon. But then in the second stage, we had exposure to street law. And who would you think would be there to teach us street law there, And it was, this living legend. We have this today with us, Professor Mrk Mason, who came all the way from South Africa to Bangladesh. And that was my first interaction with David in those days. And we went around, not only in Dhaka, but remember trips to Chittagong. And we went to the slums, we went to different places, to the law colleges. And Professor David was speaking, and he was just, explaining his ideas and experiences of the street law to me, to my students, to my colleagues. That is something that inspired us greatly to bring in and probably add these attributes and these ways of legal education, the new components of legal education into the Bangladesh legal education system. And then we went into the third stage of our clinical experience, and that is establishment of the law clinics themselves. It was initially in the University of Dhaka, where I worked, and in the University of Chittagong. And again, as Professor Bliss, Lisa mentioned in her presentation at the very outset, that the Ford Foundation, even in the United States of America, had contributed significantly to the development of the clinical experience. And so was also the case in Bangladesh. It was the Ford Foundation, along with the Asia Foundation, who came forward and sponsored the law clinics in the University of Dhaka, University of Chittagong, and subsequently in the University of Rajshahi. And to this day, we continue the clinical program in the University of Dhaka in the way that we started in mid-90s of the last century. However, I must mention that the law clinics that we established in the universities were basically, trial advocacy clinics. Since in Bangladesh, the law teachers are, they do not have the right of audience in the court of law, not to speak of the students as in North America, so that they have this privilege. So we were confined to having only these trial advocacy clinics, and we still continue or imparting the basic advocacy skills to our students so that when they graduate, at least they have the minimum acumen and skills of a lawyer, and they do not fall into the ocean in an unknown world all by themselves, learning at a later stage in their life. So this is what we've been doing in the clinic. But let me tell you one thing, that street law had been a very, I think, instrumental in the development of subsequent stages in legal education in the country. And we owe so much to this man, on the screen, Professor David. We owe so much, David. I don't have words to express my gratitude to you, not only in personal terms, but in terms of the national sort of, sense of gratitude to you. The way that you brought the message of street law in Bangladesh, and the way we tried to translate it into action. And this is where I'll be talking about now a bit. That so with this idea of street law, as a matter of fact, that was me running the show in those days. So I sent my students to the slums. I sent my students to the government industries. I sent my students to the street vendors, teaching them about the minimum, knowledge of the law that they have to know in order to protect their rights. Now, so as they're doing, so what happened? We encountered so many problems. So, the slum dwellers, they would raise, hundreds of issues, and they wanted my students to come up with answers, which they didn't have. They couldn't offer legal advice. So what we did, we now attached these, we refer these cases to the different human rights NGOs operating in the country. So Bruce, now you know that how we work closely with BLAST. So these associations started back in the 1990s, with BLAST, with BELA, with other human rights organizations. We started all this experiment, sending my students there and taking these, live clients from the street, from the slums, and bringing them to the doors of these, NGOs. But then one thing, I understood at that time, that even in the NGOs have their own agenda. The NGOs have their own, philosophy of work and thinking. So, and I found that at the end of the day, it's the same. The way that you're sending them to an NGO or you're sending them to a private attorney, the difference is very little. Ultimately, these disempowered, this underprivileged, vulnerable group of people, they are at the same level of their life as they had been prior to their interaction with the attorneys or with the NGOs. So that, the lesson I learned from this experience was that we need to have a new breed of lawyers, a group of lawyers who would be poor friendly, who would be pro-poor lawyers. And that, how to do it in the traditional way that legal education is being imparted in the country, that is something inconceivable. Therefore, what I started is a serious but very intensive residential human rights school for the law students. And there again, I had the good fortune of having the association and company of David, of Professor Menon, and Bruce, yet to come. You've been promising ever since, but I hope that someday it comes true in the near future. So, we have been these people coming, and Jane, by the way, Jane Shukoski, wonderful person, and the way that she associated herself with the summary skill concept. So we have been doing this since the year 2000. So we've been producing this new breed of lawyers through, bringing about a fundamental change in the mindset of the students of law, that how they can deliver the public good and not private good, the public good that Professor Menon spoke about, that he emphasized so much in his sort of whole life of life as a lawyer, as a law teacher. So now you see, when we started this summary school sort of experiment, then gradually I understood that we need to have this new breed of lawyers who would be lawyering differently than the existing traditional lawyers. And that I, use the term rebellious lawyers. Very fondly I call my students and these lawyers rebellious lawyers. But how these lawyers would be different from the traditional existing lawyers? And there I mentioned 5 criteria, 5 characteristics of the rebellious lawyers. Number 1, the rebellious lawyers who know that there are legal and non-legal approaches to any problem. Number 2, knowing how to work with others at fighting social and political subordination. Number 3, understanding how to be part of coalitions, how to build them for greater than litigation interests. Number 4, nurturing sensibilities and skills compatible with a collective fight for social change. And number 5, doing the work that is lawyering from within, close to the ground. So these are the 5 characteristics of my understanding of the figure of a rebellious lawyer. When we started this summer school and rebellious lawyering, then the slogan that we had is lawyering for the poor is lawyering for justice. I repeat, lawyering for the poor is lawyering for justice. And we have been, sort of experimenting with this message, I think for 6-7 years. Only at the end of 6 or 7 years of our working with this group of students, with these rebellious lawyers, then it came to my mind, I understood that when we are lawyering for the poor, then the lawyer is still residing above the clients. So the empowerment of the client is not taking place. And without empowerment, how do you deliver the public good? So this is what we understood almost after 7-8 years of our beginning of the experiment of the summer school program. So after almost 7 or 8 years, then we switched over and we changed the slogan from lawyering for the poor is lawyering for justice. So now we say lawyering with the poor is lawyering for justice. So this changing from for to with, that took us almost a decade, you see. That almost took a decade. But now we understand that we are in the right path because we are, training our students, giving them the sense that you must get rid of the 3 P's of a traditional lawyer. P, power; P, position; P, privilege. Get rid of these 3 P's in order to be alongside and at the same level with the clients. Empathize with your clients, and only then the true empowerment of the communities would take place. And that is what a public good would be. That is what human rights lawyering would be. That is what law students of 21st century are for. And lawyers, I think predominantly in a country like Bangladesh, we don't have any other alternative to serve the people rather than being rebellious lawyers. However, when we thought that it has to be leadership and empowerment of the communities, then I thought that we need to go further. So why did we added a new component to the whole, and you can call it clinical component, you can call it any way you want, but I think the whole gamut together is our clinical experience. And the latest the component that we added to the experiment is what we call the CLR, the Community Law Reform Project. What do we do in this CLR? In the CLR, we pick up the best of the people lawyering who have demonstrated their skills of poor lawyering during the days of the summer school. We send this group of students, around 12, supervised by teacher, to a vulnerable community, and these students have to stay with the community for around 3 months, not at a stretch, but with breaks, depending on the law school schedule and so on and so forth. Now these students, they live with the community, they see the community, they live the life of these poor people, of these disempowered people, of these marginalized people. They not only feel, but they also experience the sufferings and the deprivations of these poor and the vulnerable communities. They do the research, and during this time they also identify the potential leaders of the community, and they potential leaders, we train the students, these rebellious lawyers, they train the potential community leaders, so that at the end of the day, these leaders would be representing the community, and none from outside the community has to take up the leadership or give them directions. They can have the support. I always tell them that we can at best be their comrades. We'll be their comrades. We'll fight along with them. But the leadership has to be with the community itself. Therefore, we need to train these community leaders. So along with the community leaders, so this is the experiment that we are conducting. This is the work that we are conducting. This is the way that I visualize legal education in a country like Bangladesh. So I say to my students that, my dear students of law, you are not here to be litigators. Forget about those days of litigation. I tell that the best of my law years are those students who are the best and efficient community organizers. So community organizing, that is the number one duty, number one task, number one responsibility of the lawyers of today in a country like Bangladesh. And I believe that the Indian society, the Sri Lankan society, the Nepali society, the Bhutanese society, it is no different from the society in Bangladesh. And therefore, this is what we are lacking, this is what we have, and this is what the future of legal education is going to lead us to, which is, I would again say, that we must have these rebellious lawyers trained and put into action to fight for change. And at the end of the day, it is lawyering with the poor, is lawyering for justice. That is the objective that we are pursuing. And I hope that I have learned all this, not something that has come up from my own mind, but this is what I learned from David. This is what I learned from Professor Menon. This is what I learned from Bruce. This is what I learned from Jane. So it is the cumulative wisdom of the people, cumulative wisdom of the legal educators around the globe, that probably I tried to put it into into formula, and trying to implant it and see how it blooms in the realities of a country like Bangladesh. I think just a few words on COVID-19 and the rebellious lawyering. I think COVID-19 has demonstrated more than anything else how discriminatory the society in Bangladesh is. How big is the rift between the rich and the poor? How big is the rift between the powerful and the powerless? This cannot be something, this cannot be the vision of a just society when we, the legal educators, talk about delivering justice. So this discrimination has to go. And therefore, the lesson that I take from COVID-19 is discrimination is there, and we have to fight this discrimination. But in order to fight the discrimination, those who are discriminated, those who are victims of discrimination, they must be empowered in a manner that they can fight discrimination themselves. Because at the end of the day, the truth is, if poverty is to be eradicated, poverty must be fought by the poor themselves. And that is the philosophy of rebellious lawyering. And with this, I think I would beg excuse, and thank you very much for giving me a patient hearing.
Professor Rahman, it was indeed a delight to listen to you. Thank you so much for that very fiery and passionate, speech. I must say that for all the young minds in the audience, that would have been a very, very, very inspiring speech. It was only, and we're also delighted that, with the sheer knowledge and experience that the panel that we have today possesses. And we're hoping that we can get the maximum, students and attendees in this webinar can get the maximum out of the experiences and the exposure that all of you have had with this subject of clinical legal education. Now, moving on to our next speaker, we've kept him waiting for a very long time. It's way past dinner time in his jurisdiction. Ladies and gentlemen, our next speaker is Bruce Lasky. Bruce is a partner and pro bono head of the Thailand-based law firm Lana Lawyers. He's also the co-founder and director of Bapsicle. I always wondered what Bapsicle was, and I realized when I Googled it, Bapsicle stands for Bridges Across Borders Southeast Asia Community Legal Education Initiative. That's quite a tongue twister, Bruce. Bruce is also a member of the board of directors of Global Alliance for Justice Education and an international organizing committee member of Asia Pro Bono Consortium. He's had 29 years of work experience in assisting pro bono initiatives, legal aid, clinical legal education, and justice training work. He began his career in 1991 as a practicing criminal legal aid attorney and intern supervisor at the University of Florida's College of Law. He's had more than 20 years of experience working in developing countries and countries in transition, implementing education and community empowerment projects, including work focusing on pro bono, clinical legal education, access to justice, and legal aid. Ladies and gentlemen, I present to you Bruce Lasky, coming all the way from Thailand.
Thanks, Ajay. And again, it's a real pleasure to be here. And of course, looking out and seeing so many people on this session, on this panel. And also, I know that so many other people have connected in and are listening. So if you're out there, thumbs up to all of you. And I don't want to repeat a lot of things that have been said, but I've been listening to much of what has been said. I want to say that I have been in the Asia region for over 20 years, and a large part of what I've been able to help out here with is the strengthening of clinical legal education programs, or I actually refer to them as justice education programs, which is broader than clinical legal education. And that's important. In doing that, I was asked, Bruce, how did you all do it? And it's not myself and it's not Babsicle, it's a whole group of persons. It's thinking back, it's Mizunur and David who have been, lock, stock, and barrel along with us throughout. I think back to 2005 with them coming out to Cambodia to the first Southeast Asia regional clinical gathering, and they helping with others. I think about Lisa, meeting Lisa, I think maybe the first time in Manila at a GAGE conference and focusing on public health and clinical programs. Prasad has been out to Vietnam with us. This global clinical or justice education movement has been amazing. With that said, probably a lot of you that are listening want to get an idea of, how has it happened, but how will it continue to happen? And of course, Mizunur was brilliant, and inspiring as always. And Lisa started off by really saying that, when you look at the historical movement of clinical programs, and a lot of it didn't start in the United States, but let's say it gained a real momentum in the 1960s and into the 70s because of social justice issues. So when I began to assist in developing clinical programs or justice educations out in this region, I reflected on myself, and I'm not from Asia originally. I'm originally from the United States. I went through a clinical program at the University of Florida. I went through an externship program, and I was a public defender clinical student. And I reflect on that and think about, hey, look, I went through a clinic, and when I first went to law school, people said, Bruce, what area of law are you going to practice when you get out? And I said to people, I have no idea, but I know I'm not going to be a criminal defense lawyer. And then I went through a criminal law clinic, and I became a public defender for almost a decade because of the experience that I went through in a clinical program. So I reflect on that, and I reflected on what I went through in the United States and how that would apply out in other parts of the world. And actually, I came to realize that much of my experience in the clinical programs in the United States, as great as they were, in many ways were not fully applicable in so many other parts of the world. But one thing was absolutely the focus that clinical programs or justice education programs focus on social justice. And this is important because when I first came out to Asia and began to assist, there was a lot of argument between this clinical movement. I think David knows it and Lisa knows, Mizunur, is clinic about skills? Is it about social justice? Oh, well, we don't know. Is it about this or that? And, you know, from the get-go, I was like, look, it's about social justice. It is. And I would tell people, if you don't think it is, you're wrong. And people would say, Bruce, you can't tell people you're wrong. They're wrong. I'm like, okay, but they're wrong. And they are, because skills come. You could have amazingly skilled lawyers and legal service providers. And you could have brilliant lawyers and legal service providers. But that's not what justice education is about. And it's about this. So if you're watching, and I think most of you who've worked with so many offices, with Gage and Babsicle, you understand this. There are three core components to justice or clinical legal education. The first component is that people develop knowledge. So if you're out there, I want everybody touch your head. That's the knowledge. So everybody on this session, let me see you touching your head. Rao, touch your head. Mizuna, touch your head. Great. Okay. The second thing is it's about skills, and we do this. We say, look, skills, there's skill writing, there's skills in research, there's speaking skills. It's about, they have skills. So we have the knowledge and we have the skills. But the real core component, and by the way, in the back, that's my wife, Wendy, who's also one of our co-directors of Babsicle and has done as much, if not more, than I have in strengthening justice education. The third component, and this is really it, is everybody touch your heart. So wherever you are in the world listening to this, everybody touch your heart, because that's the values. And this is what I learned from David early on when I think I met David at a legal aid conference in Budapest in December of 2002. And we began discussing justice and clinical education. It's the values. And when we began to assist in developing clinical programs, and people would say, oh, it's skills, and I said, look, it's about values. Everything else comes. The great thing is people also get better knowledge and better skills if the clinical programs are done correctly. So what we said was, hey, when you're developing out these programs, we have what you call the must, what the programs must have, and what the programs may have. So we have the must and the may. And the may, as Lisa said, look, in the United States, they have all these specialization clinics, and clinics may be specialized. Fantastic. You may have, as you said, animal law clinics. You may have health law clinics. That's a may. And that's great. But when we're talking about real development, you need to first make sure you have the must. And the social justice is the must. Another must is you've got to ensure that you have inspiring people. And what Mizunur just presented, that's the example of the inspiration. You have to have these inspiring models. If you've done anything with Lisa or Prasad or Rao or Dave, you have to be able to inspire people. And last year, I was actually in Nepal at one of the Asia Pro Bono conferences. And at the end of the conference, where we had clinicians and legal service providers, we asked people to reflect on who inspires them and thinking about that. And actually at the time, Mizunur was there with his daughter Arpita, who's also a law teacher and a law professor at University of Dhaka. And he was her inspiration. And she came to me afterwards and said, thank you, because my father was there. And thank you for recognizing that's what drives this movement. And that leads us into what we also discuss in this whole region is, and if people have been with us for years, they get it, we call it the pumpkin seed philosophy, or the watermelon seed, or whatever you want to call it, you know, where if you take a pumpkin seed or a watermelon seed and you plant it in the ground and it grows on a vine, a connective vine. And it grows 6 pumpkins, 7 pumpkins, but they're connected. They're not separate. And that's the idea of strengthening clinical programs in justice. They're connected. And when you open up a pumpkin, it's filled with other seeds. So you plant those seeds, and then they grow more vines, and then it grows and it grows and it grows. And this has been the real philosophy of this movement, not just in Southeast Asia or South Asia, but globally. So many of us are involved in the Global Alliance for Justice Education, where we have created convenings yearly and every other year, where we get together connected and with inspiring people and working together with the more senior pumpkin seeds, and then those sort of middle level. So I think I'm sort of in that middle level, although after almost 30 years and with less hair, I'm getting more towards the top. And then thinking about the next level of pumpkin seeds. And today, when we were talking about this webinar, I sent out an announcement around the world, and so many people wrote in at different levels of pumpkin seeds that wanted to be involved in this. And that has been so important in this development. At the same time, we've also been very clear in these values, and everybody touch your heart again, that clinical programs of justice education are not about competition. And our organization, BAPSICO, one of our values is, if you won't help others, we won't help you. So we've gone into countries and we've come to universities and we say, look, are you interested in clinics? And they're like, I have no idea what a clinical program is. And we're like, well, we explain it, and and they're like, well, we're the best university, we're the best. And we're like, maybe you're not the university we want to work with. We're not looking for the best. We're looking for the people that are willing to work with others. And maybe that is the best, but maybe that is the best university, but it isn't always. And often you go into countries and you see it's not the top ranked universities that have those values, but it's the other ones that are willing to work with others. And that has been a real success. And eventually those top universities that early on say, oh, we're not interested in clinical programs. And I think that was probably the experience in the United States, and Lisa can probably support that. Later on, as they see these other universities having amazing programs, they jump on. Lisa, right? Thumbs up. Yeah, that's it. And so, supporting each other is just a core value of how we've made it happen. At the same time, people have come to us and said, hey, Bruce, how do universities start clinics? And we're like, don't start with money. And people are like, what do you mean don't start with money? And Lisa early on said, well, we had all these grants and everything else. And I can tell you, in my experience in this region, you start with money, you don't get the right values. You get people often that will jump on for the money, but not for the values of the social justice. So go in there, create the idea. Often it's driven by the students, but without a lot of resources, and start small and then see what you can do. And with that, you focus on different type of programs. Now, out in the region, street law has been amazing. Amazing program. Externships, amazing programs. We have some live clinics, which are great, but there are other type of clinics. We use a lot of justice mock trials that have real justice values that don't cost barely anything to do. And when someone comes and says, well, we can't do this unless we have money, I'm like, we'll talk next year when you figure out how to do it without money. And then when we get money, we can possibly do more, but don't be thinking about it. And in this time of COVID, because I'm gonna make this short, COVID being the challenge, really COVID and this pandemic has been a real model of what clinics represent in overcoming. And one of the ways that we've worked with universities and clinics really throughout the globe is we often have workshops and we say, list all of your challenges. Make a list of everything you think of why you can't create a clinical program or why you can't. Make a long list. And we get all these people and they're happy to write all these problems they have. And then we say, great, put that list on the wall, but turn it upside down. And on every single one of those problems, turn it into a positive thing. And if you don't have money, oh, we don't have money. It's like, that's fine. That means you can create a program that doesn't need money. So when you don't have money, the program doesn't close its doors. And that's a lot what like COVID, this COVID pandemic has been. In this region where things have kind of had to go online and such, we've been able to work with a lot of programs and have them focus on foundational infrastructure, creating policies online now, really learning how to do online teaching much better, thinking about how to do virtual outreach to clients in ways that they never thought about before, because why would you do virtual outreach? Clients who just walk through the door like, no, can't do that. So now they're thinking about how do we actually reach out to more clients. We assisted in the Maldives in help them thinking about developing clinics. The Maldives have Male, which is their capital island, and then they have hundreds of islands outside of there with no lawyers. So how do people get to Male to meet? Look, they can't. And I think if we talk about Bangladesh, if we talk about India, South Africa, we talk about rural parts of the United States, people can't always get in. So this whole idea of COVID and the need to do virtual, just like we're doing, that's a challenge turned upside down into a positive thing. So that's it. Be inspiring. Thinking of, you got the knowledge, you got the skills, but focus on those values. Work together, support each other, and this is the real formula. It's a pleasure, it's an honor to be a part of this. Thank you, and let's just keep creating those pumpkin seeds. Thank you very much.
Thank you so much, Bruce, for that excellent insight into your experiences in legal aid and clinical legal education. Now, we're running really short of time. Quickly, now we move on from Thailand to the sunny, sandy beaches of Rio de Janeiro. Ladies and gentlemen, we move on to our next speaker, Dr. Daniel Brantes Ferreira, who is a professor of law, an arbitrator, and a lawyer based in Rio de Janeiro, Brazil. He's a vice president for academic affairs at CBMA, which is a Brazilian Center for Mediation and Arbitration. He has a PhD in constitutional law. Dr. Brantes Ferreira is also a research fellow at the Baldi Center for Law and Social Policy at Buffalo Law School, and he is the editor-in-chief of the Brazilian Journal of Alternative Dispute Resolution. Without further ado, may I please invite Dr. Daniel Brantes Ferreira to make his presentation, please.
Thank you, AJ. Thank you for the kind invitation, and thank you for all the professors here. I've been learning a lot from you, and it's kind of challenge, quite a challenge to speak after such good panelists. But I think I'll do my best. And I just, Professor Prasad, Professor Raman, I've been learning this concept of community, like the peacemaker, the community helper. We don't have it that quite a bit in Brazil, but I'm gonna try to implement that. I think in the US they all say peacemakers and peacemakers, the lawyer as a peacemaker, but in Brazil I think we have to get a lot of ground to reach that concept, and I'm gonna talk a little bit to you about it. And I'm sharing my screen here. Can you see it? Can you all see it? Yes?
Yeah. Yes, we can. Yes, we can.
Okay, perfect. And so let me just say this, I just prepared something real quick here. I know we're short of time, but this is my presentation agenda. And so I'm gonna talk about the Brazil and the status of legal education for a little bit to start. And in Brazil, they say sometimes that someone that uses PowerPoint has no power and no point, but I disagree on that point. I think we can make a better presentation on that. So this is actually my agenda. I'm going to talk about the status of legal education a little bit, CLE in Brazil and methodologies, the clinical studies here in Brazil and methodologies, and the latest trends and what we're doing during the COVID pandemic. So Brazil, just to so you guys can picture, Brazil was discovered in the 1500s by the Portuguese. So our legal education is mainly influenced by the Portuguese. And of course, we're a democratic country, and the legal system is not influenced by religion, even though we have the Catholic cross in our Supreme Court and our Congress. So I can say that 78% of our country is Catholic. And our first constitution is back in the empire, 1824. And we are now in our 7th constitution, the democratic constitution of 88, just after a more than 30 years period of dictatorship that we lived here in Brazil. So this constitution lives until today. We're kind of different than the US, for example, because we have more than 100 amendments in our constitution, the federal constitution. And for example, the US, it has 27 amendments in their constitution, and it has 200 years more. So but and the states' constitutions, they are almost like a copy of the federal constitution. So they don't have that kind of autonomy that they have in the United States, for example. And we have 5 regions, 26 states, and 1 federal district, Brasilia, where the government is the center of Brazil. And we have more than 5,000 municipalities. So we're divided in federal government, states, and like I would say, counties and municipalities. And we have a 210 million population, which, if you compare to India, it's almost nothing, because we have a huge area. But most of our area is covered by the Amazon forest in the center of Brazil, north of Brazil. So the area is not populated. The big part of the population, most of the part of the population, is in the south and southeast of Brazil. So are law schools, as we are gonna see right now. So the public, actually the universities are divided here in Brazil between public and private schools. Public schools are completely free, no tuition at all. So you have the federal schools, the federal university, and the state universities. And as I put here, you have 296 public schools in the US. Each 22 of the 26 states have state universities, and we have 69 federal university institutes, not only universities, but institutes and other schools. And every state in Brazil has 1 federal university. And private university, we have tons of it. We have more than 2,000 private universities, and they are paid. I'm saying that public schools are completely free here because they are not in the US, for example. I think when you live in the state, you have some kind of scholarship when you are born in the state if it's a public school. But in Brazil, they are completely free, but they lack infrastructure. They have good professors, but they lack infrastructure. And for example, the clinics are not that good because they have good people working, but not a good infrastructure to work with. So just as a comparison, Brazil, I think it's the country that has most law schools in the world nowadays. We have 17 and 3,100 law schools here nowadays. 13 new ones just got approved, accredited yesterday. So if you compare to India, I got the number, we have 1,600. And if you compare to the US, have 237 law schools. So that's a big massification of the legal education, which is good in some way, because a lot of people can get access to legal education, more people actually, but not all schools are that good. So we think, what kind of lawyers are we graduating? And they're gonna be out there helping people, but maybe they won't help them. They will get in their way if they're not good professionals. So that's one kind of discussion that we have here in Brazil. As for the clinics here in Brazil, we have the 2 first law schools in 1827. Back in the empire. For example, we had slavery here in Brazil until 1888. So the first law schools were created mostly to produce the lawyers for the government, for the empire back then, the Portuguese Empire. And they were in São Paulo, which is the financial hub until today in Brazil, and in Recife, which is in the northeast of Brazil. And the universities here in Brazil, they were created they were created with the French influence, the Napoleonic model, which is a lot of colleges together, but they are seen as individual, as alone. So they are separated. They don't communicate between them, and that still happens nowadays in the university, lots of the universities. And as for the law schools, our influence is Portuguese. The first lawyers in Brazil, they came from the University of Coimbra in Coimbra, Portugal, and they went there just like in the U.S. They went to Oxford after the colonization and after the independence. But there's a difference between U.S., for example, and Brazil. If you read the book The Ages of American Law from Grant Gilmore, he says that the U.S. law, they have three phases, and the first phase was the age of discovery. When the U.S. declared independence, they really declared independence, and that means in legal education also. And so what happened is that the Americans, they started producing their own material, their own law schools, and they really wanted the independence from the English jurisprudence, I would say. And that didn't happen a lot here in Brazil. We still, today, we drink a lot from the Portuguese, we take a lot of influence from them, and vice versa. They also get a lot of influence here from Brazil. And as the clinic study, as a requirement, it started back then in '63, but not clinic offices, working, just, the course, the theoretical course of clinics. And then in '72 also, but it starts to be mandatory to have the law school to have a specific clinic office, so the students could work with, we call here in Brazil the supervisor in the clinics, the professor lawyer figure. It's not the supervisor, called the professor lawyer. It's like it's like a hybrid figure, the professor dash lawyer. He's not a specific professor because he's not in the classroom, but he teaches the practice, so he's a practical professor, I would say. And then in '94 it became mandatory, and we have in Brazil the national curricula guidelines for the law schools. Not all the courses have guidelines, but the law course is really important. The government sees as an important field, and so it regulates more the law field with the guidelines of the Ministry of Education. And for example, the two courses that you have trouble of authorizing, the requirements are bigger, I would say, is the med school and law school. Med school you can open. If you want to open a med school here in Brazil, you cannot. It's closed. The window is closed. It only opens when the government wants, or it needs a med school in certain regions. But the bar, the federal bar committee says that they should close off that window also to the law school nowadays, to open new law schools. And that's really a fight between the government and the Brazilian and the law schools, the private law schools, because they want to open more law schools here in Brazil. But you want to say anything? Can I keep going? Can you hear me? All right. Is it good?
Yes, we can, Daniel. Please go ahead.
Okay, sorry. So, what are the law schools requirements and legal clinics requirements? For example, in Brazil, it's an undergraduate teaching. The first degree in law is undergrad. So you get out of high school and you do a 5-year course and you get a bachelor degree in law. So, and the law school must have a minimum of 3,700 hours minimum. So if you want to have a good law school, you get it way past that. I was the dean of 2 law schools here in Brazil, and one was an Ivy League law school, and I have 4,508 hours. So I had the best bar percentage of approval percentage. So I got like 1,000 more hours than the minimum requirements. And in this 3,700 hours, you can have 40% of online teaching. You cannot have an online degree full online degree in law here in Brazil until now. Most of the courses you can, like business, economics, accountability, but accounting, but not in the law school. You cannot have, and that's being a fight between the federal bar, the Brazilian bar committee, and the government, because the government wants to approve online law schools, but the bar is barring, of course. It's not allowing, specifically because of the clinics. They say you cannot do clinics online, so you can have a law school fully online. And maybe that's gonna change right now after this crisis. I don't know, but that's the main argument of the bar. I know because I used to evaluate, accreditate law schools for the Bar Association. Was the president of the Bar Association for Legal Education here in Rio de Janeiro. So when you want to accreditate a law school, you gotta pass through the Ministry of Education, and right then it goes to the bar, the Federal Bar Council, so he can approve or not. But if the Federal Bar Council doesn't approve the law school, it's gonna exist anyway. It's gonna be approved anyway. So it's more a consulting function, a consulting role than he cannot put the red tape on it. But okay, so if you want to make a law school, build a law school, you have to divide it in 3 axes. And that's the practical, that's the general formation, where you have the first 2 years courses like sociology, philosophy, and courses like that. And then you have the technical legal training, where you have the specific dogmatic courses like tax law, civil law. We are a civil law country. We're not a common law country like the US and some part like India. But of course we have the practical professional training that's specific, the clinics. So you have to build the course over these 3 axes, and the clinics must be in the 2 of the 5 years, in the 2 last years of the 5 years of the law school. So that's mandatory. You can make the clinics before. So when you are in the 2 last years, when you are a 4L or a 5L, you do the clinics. And usually in the traditional courses, traditional areas like civil law, mainly family law and consumer law, and labor law, and so areas, criminal law, areas like that. Usually the law schools make the traditional areas, build the clinics over the traditional areas, and clinics must have, together with the additional activities, extracurricular activities, they must represent 20% of the workload of the entire course. So if you're talking about 3,700 hours, they must be 20% of that. If you have more, they must compose 20% of those hours. So I'm gonna give you now real quick the perspective, 3 different perspectives, because I've been in in those 3 roles, which I think is kind of hard here in Brazil. So I'm part of the accreditation body, site body for the Ministry of Education. What I do, I go to the sites and I approve or not a new law school, and they have an instrument that you must follow for the clinics also. But when you go to a site to approve a law school, they actually don't have nothing, just the building, the infrastructure at that time, and a pedagogical project. So you analyze the pedagogical project for the course, and they don't need even to have the clinic office already, but they must present the project, the blueprint at least of the clinics and the areas, what they're gonna do with the clinics. So when you go as represent the Ministry of Education to approve a new law school, you must check what are they gonna do. Are they gonna help the community? Do they have the certain areas that they need? For example, one of the requirements is to have mediation, conciliation, and arbitration inside the clinics. So they must write at least that they're gonna do and how they're gonna do mediation. Arbitration is kind of hard to do in the clinics because only with externships you can do that, but mediation is pretty popular nowadays, in the clinics here in Brazil. So as a law school dean, what did I do while I was law school dean of I was 2 law schools here in Brazil. You know, we had the traditional areas, traditional fields in the clinics, like criminal law, civil law, but I tried to create specialized clinics. And so I had in one law school the diversity clinic office. So we got transsexuals, we got every kind of people to help the community. But when you create a specialized clinic office, you must attempt to have a good pipeline of clients, I would say. So we made partnership with NGOs mostly, like rainbow groups and things like that, so they could send people for us to help. And that was a really good activity. And in the other law school, I created the clinic for violence against women. We were located in a place in Brazil where the rate of violence against the women the crimes against women are really big. So we created this kind of clinics, and we had really success in that. You know, the women just came. We made partnerships with the police station specialized in women. So they came here, and you have to take care when you create a specialized clinic like that. You have to put, for example, only women lawyers to attend those kind of women that suffer violence and things like that. So you have to think about everything. We had a psychologist there also, so you have to think about everything, not just the law, but you know, how you're gonna treat people when they come in and when they knock in your door. And at the bar, I was the former president of the Legal Education Committee here in Rio. So the vision of the bar here in Brazil, they don't want to open any more law schools, because the rate of we have the bar examination after law school, just like in the US, and the rate of approved students is just like national-wide is 15%. So it's really low. So the bar states that we shouldn't open more law schools. So when the new law schools go to the bar for us to approve or not, for example, in the last 2 or 3 years, we had 500 new law schools going to the bar to be approved, accredited or not, and they only said yes to 1 law school. So they are pretty much against creating new law schools, and they are really pro the clinic to help the community. So what we do as a methodology here, use basically active methodology. So students work with MOOC cases, and they help the community. They get real cases along with the professor supervisor. And the clinic mission here in Brazil is to serve the community. So, and we have family, and it's the most popular area is family law. So they do divorce, a separation of couples, and you know, that's the main thing of most of the law schools here, the clinics in Brazil. So what skills and competence of the students and of the alumni you're gonna develop, it's up to you. It's up to your pedagogical course design. And so you define that, and you create your clinics observing that. And what are we doing during COVID? So I got the data from the Sistema Faculdade, which is a software specific for clinics. And I know the director, and he sent me some data. And I think it's the best software available here in Brazil, because it lets you to follow all the professor lawyer steps and all the student steps, and you can evaluate all the skills and competence that are being developed, and all the things the students is actually doing. And so for the manager, for the dean or the clinic manager, it works really well, and you can show the data, the evaluation process to the Ministry of Education when they come. The committee comes again. So it's a really good software for that. And you can follow, of course, externships also, because they have a lot of externships. So just for you to get a picture of that, they have this software is already 32 law schools here in Brazil, and they just got 8 new law schools because of the COVID crisis. So they made 8 new contracts after the COVID crisis, and they have more than 10,000 students here. And the monthly access after the crisis, the pandemic, increased 51%. So people are really going online. They are really doing the clinics online. Of course, to get the clients, to get meetings with clients, they use Zoom or other software like that, but it's increasing a lot. And that's one thing that we use here in Brazil. Otherwise, when we're not in the pandemic, we also use the software, but it's mainly face-to-face. They go to the office and they serve the community, and that's what happens. So they learn a lot of that. But I can say that usually clinics, unfortunately, clinics in Brazil are really underestimated by students. Some of them think that's just something that they have to go through, but their learning is going to come from the law firms mostly. And so not all the students take it really seriously, the clinics, and that's a shame, but because it's the opportunity for them to learn other areas and to get from to learn from other experience from the professors and from the public. And so my final note is that here in Brazil we have to develop a lot, but we're going the right way as clinics. And for you to get a clinic service, you have to be poor here in Brazil, and you have to get the top 4 minimum of our minimum wage. Of course, you have to your earnings can't go over $1,000, I would say. So and that's not very good money here in Brazil. It's an expensive country. So CLE is a vital part of law schools, and as a dean, I always saw it as a vital part to get prospects, to get new students, and to retain the students that I have, because because it attracts new students if you have a good clinic, if you have a good practice. And I'm also against going fully online, only times of need. I think face-to-face, nothing can overcome the face-to-face and the body language and how you feel the client. And I think that's impossible to overcome. But and I think also, and I leave this in the final message, that it's still underestimated by students, but I think they should overestimate, and they should use the clinics a lot better here in Brazil. And so the law school should also see, not all of them do, as a vital part of the law school. Thank you very much.
Thank you, Professor Dr. Daniel Brantes Ferreira. Muito obrigado. That was a very interesting insight into the legal education and the clinical education scene in Brazil. And quickly now we move on to our last speaker. Before we go on to Professor Sri Krishna Deva Rao, who unfortunately could not join us at the very beginning. So his inaugural address, we're going to turn that into the closing remarks. Professor Rao, we would be grateful if you could actually deliver, adapt your speech very quickly to be the closing remarks. And
Yep.
Thank you, Professor Rao. And now we have with us the last formal speaker for today. We have a very special person. He's a special person because I attribute all my knowledge relating to clinical legal education to this gentleman. This gentleman's name is Professor Mrk Prasad, and I've had the privilege of being a student almost 25 years ago, way back in the good old days at the Salgaocar College of Law in Goa. Now, Professor Prasad is the principal of the VM Salgaocar College of Law in Goa. He's a leading expert in clinical legal education in India and was the first recipient of the Vanderbilt Fulbright Scholarship in clinical legal education. Professor Prasad was instrumental in establishing and functionalizing India's first legal aid setup run by a law college at the Salgaocar College of Law. And for this initiative, the college received the Institutional Excellence Award from the Society of Indian Law Firms. He has assisted the Indian University Grants Commission to develop e-content on access to justice for his project on e-Pathshalas for postgraduate courses in law. He's also contributed to course content for the School of Law at the Indira Gandhi National Open University and is a former professor of law at the Indian Law Institute in Delhi. So ladies and gentlemen, if you would ask me, if I were to sum up this gentleman, I would say he's one of the rock stars of the clinical legal education scene in India. So ladies and gentlemen, please allow me to welcome Professor Mrk Prasad. Over to you, sir.
Thank you, Ajay. Can you see the screen?
Yes.
Yes, we can, Professor.
Okay. So what am I going to speak is, this is how the scheme of my presentation goes. First, I would be talking about overview of legal education in India, because there are some foreign people join into, so they should understand. Then I will talk about concept of clinical legal education in India. Then we will see how there were efforts made to institutionalizing this clinical legal education. Then I will go to current trends. Then we will look into challenges and opportunities. Then we will see during the COVID what law school clinics can do. Just to give a brief idea, we had more than 1600 law colleges. We don't have exact number as such. The Bar Council of India doesn't actually publish any number in that sense. We have already had 2 million lawyers registered, and my estimate is every year 150,000 law students are graduating, because there are 1600 law colleges. Each college at least 100 students graduate. That's a huge number. I assume that we are in #1 in the world in terms of population of lawyers, because previously we were #2 to USA, but by this time we would have crossed. And if you look at the legal education in India, there are offered through various institutions. Public universities, these are supported by either federal or the state government. Then we have these corporate or private universities. Last 10 to 15 years, they have emerged as a leading players in providing legal education in India. We have government law colleges. That means these colleges affiliated to the university but independently run, and government colleges they are very few. There are private aided law colleges. For example, the Salgaocar Law College, which I head, is a private college, but aid is provided by the government. And there are purely private law colleges, and we have national law schools. Mostly in each state there is one national law school, which they are called as the premier law schools. So there are varieties of different types of institutions offering legal education, and as a result there is huge differences in quality in terms of their infrastructure, their course structure. There is a lot of differences among these institutions. And in India, we offer two types of legal education. One is 5 years integrated double degree program, which is equivalent to the Brazilian program. This is after 12th standard or high school, you could call it. We offer 5 years. They can become lawyers. Or like in America, SJD program, there is after your graduation, you join in LLB, which is 3 years course. Now, when I'm looking at the concept of clinical legal education in India, I look clinical legal education goals as 3. One is clinical legal education as a pedagogy. That means as a teaching methodology. So if you use that clinical legal education as a teaching methodology, you could teach even substantive law like constitutional law, the penal codes, contract law, etc. through clinical method. So that is completely a different set. That clinical legal education as a method of teaching. The second fold is that the clinical legal education towards skill training. That means the benefit of clinical legal education is to train the students to acquire certain skills, because law being a profession, the profession expects you to gain certain skills when you are joining in the profession, so which the clinical legal education could address it. The third fold is that the clinical legal education to improve the access to justice, that is what the most of the clinics do, that provide some kind of access to justice, maybe in terms of going to the court, maybe in terms of getting their grievances settled. So I may be completely focusing on the third fold, that is clinical legal education to improve access to justice, how clinics are started in that sense. Now, like United States of America, even in India, clinical legal education has its roots in legal aid as well as legal education reform. That means we have, if you want to learn the history of clinical legal education, you need to look into the legal aid development in India and also education reforms in law. The pre-independence, you could see that the Indian legal education dates from British rule, when the law courts were established in Madras, Bombay, and Calcutta in 1726. However, that there is no specific law college was there to offer this legal education. So the qualification to practice law came in the year 1814, and then after that the Legal Practitioner Act in 1846. But the formal legal education, that means studying law, going to a college or an institution, started in 1855, when the government of Western College first started the law program. Now there are so many other developments subsequently. Even after independence, there is no specific agency to control legal education until 1961, when the Advocates Act came into picture. So till that time, each state has different type of models of legal education. So finally, the 1961 Advocates Act established the Bar Council of India and given the power to the Bar Council of India to control the legal education. So the standards of legal education can be prescribed by the Bar Council of India, unlike some of the Western countries where they can control only the legal profession. So in India, Bar Council of India can control legal profession as well as legal education. That's one of the reasons why now every law college that is established in India has to get a recognition from the Bar Council of India. Otherwise, their students who complete their law, but they will not be able to practice in the court unless these colleges get Bar Council of India's permission. Now, as I said, that the legal aid and clinical legal hand in India, these are the three committees, particularly the 70s and early 80s. The first one is Mrk Prasad expert committee on legal aid, and second one is committee on national judicare and equal justice. Then committee for implementing legal aid scheme, that is SILAS by Chief Justice P.N. Bhagawati. These are the three basic committee reports which talks about involvement of law schools in legal aid. So I just took all the important points from these three reports. The reports says that introducing the clinical legal education in the law college must be there, and they should focus on socio-economic and poverty issues. And it also says that the law students must engage in public service while they are in the law colleges. So therefore, it suggests that every law college should have a legal aid clinic, and it also talks that the clinical law teachers need to be developed in each law college. And just to give some information about the foreign delegates and the participants, in India, neither the law teachers nor the students can actually represent any client in the court because the Advocates Act prohibits it. And even today, we are not allowed to practice. A law professor cannot practice in court, neither the law student can practice in court. Therefore, representing a client in the regular courts is out of the purview of any clinical program in India. And the reports also talks about promoting legal literacy, train paralegals to support legal aid programs, and also law students could be used to bring public interest litigations in India. I think most of you are familiar with public interest litigation, where even though my right is not violated, if the society's rights at large is violated, I could file a litigation in the court. So the early effort of establishing legal aid clinics can be dated back to 1969, where Delhi University has established a legal service. There the students used to, with the help of the teachers, used to represent the clients in beggars court, which is not actually a court, it is a kind of a tribunal. Then Aligarh Muslim University started its clinic by conducting few legal aid camps in 1980. And Banaras Hindu University is the first one to introduce clinical legal education as a course in the 1970s. And 1983-84 also established in the Jodhpur University. However, these legal aid clinics have moderate success. The reason could be plenty. There are no infrastructure available, facilities available to these clinics. There is a poor financial aid. Of course, today I may not agree poor financial aid could be a reason. I agree with Bruce that money is not the only requirement for clinics. Most importantly, there is no trained faculty, poor wages for the part-time teachers. The problem with the no trained faculty is if a lawyer to come back to teach as a part-timer, the wages are very poor, so it discourages the lawyers to involve in the legal education. And also lack of involvement of bar and bench in the legal aid clinics. And mostly those days, students are part-time, LLB courses were part-time. And most of the time, the law schools thinks that it is a law school, so therefore they are worried about how to impart abstract concept of the law, but not the skill part. Because it is not a lawyer school. Once you study law, you go to profession and learn the tricks of the profession. However, in 1987, the first national law school was established in Bangalore. Professor Madhavan is the first director. It was established under the guidance of the Bar Council of India. This is a national law school introduced this 5 years LLB program. There's a double degree program. And several non-law subjects were also introduced at the LLB level. And clinical education is one of the forefront at the time the National Law School Bangalore was established. So in fact, is the first time a refresher course was conducted on clinical legal education by the National Law School Bangalore. Now, what are the efforts made by the Bar Council of India in institutionalizing clinical legal education in India? There are two specific efforts I would mention. First one is in 1997, Bar Council of India brought a circular and made 4 compulsory subjects, mandatory subjects, supposed to be a practical papers. The first paper is moot court and bar bench relations, and second one is drafting, pleading, and conveyance. Third one is professional ethics, and fourth one is legal aid and public interest litigation. These are the 4 papers made as a practical papers, compulsory for all this law schools. So imagine with one stroke in 1997, now every college in India supposed to have a legal aid paper. And the problem with that is there are no guidance, there is no training for the law teachers, and most of the law teachers are just academicians, not having any exposure to the practice. Therefore, it becomes more difficult for most of the law colleges to start clinics. But however, there are many colleges started the clinics as a result of 1997 circular. And again in 2008, Bar Council rules on legal education changed legal aid as a compulsory paper, removed and added alternative dispute resolution as a 4th practical paper. And Bar Council insisted that every law college must have a legal aid clinic, and all the final year students must be members of this legal aid clinic. That means on 5 years course as well as 3 years course, the final year students must become members of this legal aid clinic, and the law colleges should offer legal aid services through this clinic. I have conducted a 7 states research on how the clinics are working. It was conducted under UNDP and Government of India. And we found that the majority of the clinics were started to fulfill mandatory requirements. Though there were some pockets of excellence, there are few colleges really done exceedingly well, but the most of the clinics were started with mandatory requirements. So as a result, what happened, these clinics have no proper functional structure, like the place, what the policy, what kind of services they would offer, etc. And most importantly, in most of the colleges, there is no workload credit was given to the faculty. And to inform you that in India, as per the University Grants Commission, every assistant professor must take at least 16 hours of teaching in a week. So therefore, the clinic work became an additional burden for the faculty because it is not recognized within the part of the work. Similarly, in most of the colleges, no academic credit was given to the students. So therefore, it becomes like a extracurricular activity. As a result, both the faculty as well as the students are not interested in doing it unless they are really motivated. And another issue is that most of the activities of these cells, whatever they started, legal aid cells, are restricted only to few legal literacy camps rather than going into specialization. And also the problem that we found is that there is no involvement of the bar and the bench in the legal aid clinics. In fact, under the National Legal Service Authorities Act in India, it is the legal services authorities are supposed to have collaborations with the legal aid clinics in the law colleges. But unfortunately, either there is a lack of involvement by the legal service authority, or there is an ineffective collaboration by the legal service authority in most of the states. What are the current trends? It doesn't mean that there are nothing is happening in the clinical legal education front. There are pockets of excellence. For example, Salgaocar Law College has an excellent program of community legal aid cells. Professor Krishnadeva Rao, after he is taking over as a director in Odisha National Law School, he started a clinics there. And we had Jindal Global University has an excellent program on clinics. Symbiosis Law School, like that, there are even Delhi University has a good program. But these are all pockets of excellences. I cannot say that this is the same throughout the country, but there are good efforts made by individual law colleges. And as a result, there are some of the best practices have emerged for where the other law colleges could look into them, and maybe some of them could be adopted. But the problem with these kind of things are most of them are driven by individual passion. That means a law teacher who is very passionate about the law clinic starts in the law college, and maybe after he either retires or moves from to another college, then it largely suffers. So the institutionalization of clinical legal education through legal aid cells is very much needed at present. And another important aspect that came up with the thing is that low cost clinics. In most of the Indian clinics are very low cost clinics, and in fact there are many activities that my legal aid cells undertake as in fact has no cost at all. And few of the examples that comes from India, we have some colleges started the child rights clinic. For example, in Salgaocar Law College, we have a child rights clinic. The students go to Juvenile Justice Board and also Children's Court and help the children to familiarize with the procedure, how the victim will be sitting, where the victim will be sitting, where is accused would be sitting, what type of questions they would ask. So this kind of work that the students do. And also prison clinics were more popular in some of the national law schools and some of the private colleges. There are consumer clinics where the advantage being the consumer forum is not a court in a strict sense. Therefore, law students could represent the clients in consumer clinics. So consumer clinics are emerging as an alternative to regular court visits. So the students get first-hand experience of representing a client. and community clinics which are working in the community. As I said, we have about 25 clinics working in Goa in the community. Most of them work in temples, some of them are in churches, some of them are in panchayat. Panchayat is like counties, the local self-governments. And many colleges are very well versed with the legal literacy clinics, which is almost equivalent to street law programs in South Africa. And most of the colleges have these compulsory internship to the students, and some of the colleges also provide trial advocacy to the students. So this is the map of Goa. You could see those pink pen marks. This is where my legal aid cells work with the community. So they work every Saturday, 3 hours. So what are the challenges that we have? We need to make legal education socially relevant and professionally competent. So that's one challenge that we have, because 1600 colleges, there is a lot of issues regarding the quality. So we need to redesign the curriculum, teaching methods and materials. And we also need to identify new tools to shape the future lawyers, because now we are no more law colleges, we are lawyer colleges. So therefore, we need to reduce the gap between the law in theory and law in practice. We need to provide social context education. And the challenge for the law teachers are how to meet unmet legal needs, particularly in rural areas, because there are majority of the law schools comes in semi-urban areas. There are no law schools in rural areas. Therefore, this is going to be a big challenge. And how do we prepare the law students to meet these challenges? That means how these students should go to the community and connect with the community. This is one challenge. At least in my experience in my clinics in Salgaocar Law College, is because majority of my law students comes from the community. Therefore, I don't have any much difficulty in connecting with the community. But the national law schools and some of the private universities will have this kind of a problem, that because India, the language could be a biggest barrier. We have 29 states, we have more than 1000 languages spoken, at least more than 30-40 major languages spoken. Each state has a different language. So this is a kind of a challenge for the teachers. And also we have the challenge that most of the colleges did not understand the importance of the clinical legal education, and they did not understand even the concept of what is the clinical legal education. Therefore, there is a lot of hesitation to start with legal aid clinics. There is a lot of apprehensions that we don't have any experience. How do we start the clinic? This is the biggest block for most of the colleges. And also there is not much interaction between the lawyers and the law schools. That's one area that we need to focus. And as a result, what happened, most of the law schools spend very less resources in terms of human as well as economic resources in starting the legal aid clinics. What the law school clinics should do during the COVID, as we all know that there is a lot of mobility restrictions. I had come up with few areas. One is that the compilation of the orders, at least in India, within 2 months, the government has issued more than 4,000 circulars. Now, a common man is lost with the circulars. And even educational institutions are issuing circulars every 15 days. So there is a lot of confusion about what is the situation, what you should do if you want to do certain things. Therefore, a compilation by the law students about these things could be done. And awareness and education of COVID can be taken care by the students. And we all have the biggest problem of the migrants. The moment we impose the sudden lockdown, there are lakhs, I could say millions of migrants walk back to their cities, walking hundreds of kilometers. The estimate is that in India we had about 139 million migrants. you could imagine the massive migrant population that moves within India. So therefore, if the migrants want to go back to their their state, their home, it was made compulsory for them to register with the authorities. So those kind of activities the students could effectively. We also could look into assessing and reporting. That means various policies of COVID-based policies we could assess and report to the authorities. And the students could also involve in drafting policy guidelines and providing consultancy. For example, there are many issues regarding lockdown violations, police cases, bankruptcy issues, where the students can provide consultancy. And interstate law clinics and faculty task force, this is a very important thing, that there should be a networking between the different state law legal aid clinics, so that people living in other states wanted to travel to my state, so they could be able to contact. So I had also given the standard operating procedures for the safety measures. For example, now there is a biggest dilemma whether the education institution should conduct their examinations or not. If they want to conduct examination, what are the standard operating procedures? So maybe the students, law students, could compile, provide research support. Altogether, what I want to say is that clinical legal education has a lot of potential in India. We need to train a lot of teachers in understanding the concept of clinical legal education and how effectively it could be used for both to improve in terms of quality of legal education and also social relevance of it. I think that's it. I have nothing to say. Thank you very much.
Thank you, Professor. Thank you, Professor Prasad, for the great insight into the legal education, clinical legal education scene in India. I see that we've got just 5.5 minutes remaining for this webinar system to wind up. So may I quickly request Professor Sri Krishna Deva Rao to deliver the concluding remarks. Just in case I don't get the opportunity to come back, may I take this opportunity to thank Professor Prasad and Professor Rao for having partnered in jointly organizing this event. And thank you so much to all the wonderful panelists for being with us, and to the attendees. My sincere apologies for the technical problems and for the slight delay in starting this this webinar. So, Professor Rao, over to you, sir.
Yeah.
You have
yeah. Are you able to hear
5
me?
minutes.
Yes, yes.
3 concluding observations. Firstly, Prasad has explained very comprehensively about the clinical legal education in India. I would classify, like Lisa has said, about the 3 waves of clinical legal education in India. That was the beginning from 1970 to 86. And that was a remarkable period where all over the world, including United States and South Africa, there was a huge old and new social movement, human rights movement, women's movement, consumer movement has influenced. That was the time Indian Supreme Court was trying to come out of the post-emergency excesses, which was committed by the then government between 1975 to 77. And that was the time they were developing, Professor Upendra Bakshi, in his words he calls as a social action litigation. The journalists, the civil society, human rights groups, everybody has contributed to developing this exciting social action litigation. I think that was instrumental. That has given the social justice mission for the legal education in India. That's the first phase, 1970 to 86. 1986, as Prasad has said, the establishment of the first National Law University in India. There was a lot of discussion from 70s, 80s, how do we develop? And that was the time the government of India also has given an opportunity. They were looking at the 5-year undergraduate program like Indian Institute of Technologies, where they become just standalone universities which are offering only the law discipline. That was 1986 to 1997, almost a decade. 97, as Prasad has mentioned the first time. Before that, clinics were very well known. The legal services clinic started from 70s and 80s. He has contributed providing the future direction to the budding lawyers in India. If you look at several of the judges of the Supreme Court, the current, retired, and the future, and including the lawyers, they were part of the social justice mission. And the prison legal services clinic, you can see anywhere, all over in India, you have a prison legal services clinic. And I would say the third wave of clinical legal education is 1997 to the current one. After the Bar Council of India introduced the curriculum initiatives, and now there are several foundations are coming out, particularly the Department of Justice is coming out with supporting the law schools, and the UNDP and the Access to Justice for the Marginalized Communities major programs, and also the private foundations are coming, and the several pro bono initiatives which are there. So these are the three waves. Secondly, I would like to explain about my experiences. I have learned the law from the grassroots. As a student union leader who was involved in the criminal justice reforms, involved in the human rights and the legal aid movement, I have learned how the law works really in the grassroots. And that's the reason I prefer to coming to I worked as a trial court as a practice. And the first day when I moved a bail application, I asked the lawyer, why don't you give habeas corpus remedy in the trial court? He laughed at me. But that was the enthusiasm which encouraged me to coming to the National Law School. So my first initial experience in the initial formative years of working with the National Law School Bangalore, particularly 1990 to 98, I have realized what is a community dispute resolution. National Law School Bangalore has established a community rural mediation center just near to Bangalore. And that was a real experience where I thought not only the legal awareness strategy, legal representation strategy, community dispute resolution strategy, which people call as a third wave of access to justice, is important. And that I have learned. Then when I moved to the second law school, Hyderabad Law School, I am passionate about offering this legal aid and public interest litigation course. So 2003, a new clinical program emerged, which is called as a land rights paralegal, first time in India from this Hyderabad Law School, which came out of my course on PIL and legal aid. I have taken the student, let us study how do we resolve the revenue disputes. From there, the government of Andhra Pradesh has taken up, and the first time in India, land rights paralegals were institutionalized. And similarly, the very interesting project we have done as a part of the UNDP in the National Law University, Delhi, was about looking at two interesting laws, the Building and Construction Workers Act and the Construction Cess Act. And after studying and doing an empirical field level based in Delhi and Uttar Pradesh, we have created a mobile registration, because what is required, whether under the Building and Construction Workers Act or Interstate Migrant Act, the major lacunae is the government will not encourage, facilitate registration of the migrant workers. So we went to the various government and private construction site with the help of the students and faculty, using David's inspiration of street law, poems, dance, and other. We created a legal awareness among them, and we were able to register thousands of migrant workers and building and construction workers. And with these, we have taken to the pending writ petition in the Delhi High Court that was instrumental in bringing some reforms into the Building and Construction Workers Act, placing the responsibility, duty on the employer to carry forward the registration. I think that's where later we have started the first time a paralegal program in India in the Indira Gandhi National Open University. And in the when I came to the National Law University Odisha, I started a small pilot Barefoot Lawyers College. I think still it's in the pilot stage. Hopefully a day will come, and with all your help and support, I will set up exclusively a clinical law college, maybe a paralegal school, which I consider is an important necessity mandate of providing justice to all. So I'll close with thanking all of you. We had wonderful presentations, starting from learning from the American perspective, how the United States has contributed, and that was an inspiration for us also. We have learned several things with the Ford Foundation, helping the Indian government, whether establishing the Indian Law Institute or even in the National Law School in the initial days. And Professor David came in the 1995 to start in the National Law School Bangalore Street Law Initiative. We have our own model of public legal education, and Indian civil society is very strong and a robust street law initiative. And you name any program with the women's groups and criminal justice groups, they have a strong street law program. And then we have heard the Asia Pacific perspective from Bruce Lasky. Every time very energetic, passionate. He has his own new method of pedagogy, even in explaining the Asia Pacific perspective. We have heard our young friend from Brazil, and we have several similarities. And then we all have to, I think this is a real opportunity for more collaborations and partnership. Ajay and Prasad, I think we should continue this. How do we learn from each other? How do we collaborate? How do we partner? And we have our great friend from Professor Mizanur Rahman, who is always a constant source of inspiration for us. And we have a lot of exchanges with the Bangladesh. And we are, even though Prasad and ours, we have started a South Asian Clinical Legal Education Association, but still, I think we all have to work together and take it forward, and to see that access to justice will not just remain only in the books. It will become a reality, and the justice will be provided to all. And that is the motto, and that is an inspiration for all of us. And over to you, Ajay. Thanks for Ajay and Prasad have really worked very hard to put the conference, the webinar together. Thank you, Ajay.
Thank you, Professor Rao. It's quite a pity that we couldn't have you at the very beginning of the webinar, but I think I must say that this webinar has ended on a very high note with that passionate speech of yours. I must say I'm truly inspired. I didn't know the background to the man that is you. So thank you for giving me that great insight into your early days as a young law student, as a lawyer. So, ladies and gentlemen, I must thank all of you in the audience for being with us. I see that we all, despite us running late and having started late, I see that we've got 170 delegates on the call. And looking at statistics, I must let you know it's very heartening. Despite all the technical difficulties that we had, the statistics show that we had about 700 delegates on the call, 700 people in all who came in and went out, came back again. So I think that is a testament to the profile of the panel that we have today here. And I must say, when I was conceptualizing this webinar with Professor Prasad and Professor Rao, I said that we should prepare a wish list of the best clinicians and the best clinical law professors in the world. And I am delighted and honored that all of you who are here on this webinar accepted our invitation and made it a point to be here. You know, this gives us a lot of encouragement to continue with these collaborative efforts. And Professor Rao, I for sure will be very happy to be working with you, with Professor Prasad, And to all the ladies and gentlemen that we have on this panel, I think what we need is to continue this global dialogue that has, it's not something new. I gather that it's been there for quite some time. So I think we need to continue this, and COVID-19 has given us the opportunity of doing this through technology, by which we can have these dialogues without a great deal of effort, and without spending a lot of money. But ultimately, I must say that we are at the mercy of technology, and we saw what happened today. Everything went on well, excepting 5 minutes before the start of the webinar. So, ladies and gentlemen, from the organizers, from the co-organizers of this webinar, the National Law School, National Law University Odisha, the VM Salgaocar College of Law in Goa, and the Faculty of Law, Manav Rachna University, I thank you one and all. And all I can say, all of you, please have a very pleasant evening, a very pleasant day, and a very pleasant afternoon ahead of you. And I hope to see all of you at one of our future initiatives. Thank you very much, and bye for now.
Thank you.
See you all. Bye. Thank you very much.
Thank you. Bye.